Mr. Chairman, we are live.
Okay. If you're ready, will you please call the roll for our Judiciary Committee meeting, March 5th,
Okay.
Friday morning?
Representative Crago,
Here.
Representative Larson,
Here.
Representative Oakley, Representative Oakley,
Excused.
Representative Provenza,
Here.
Representative Williams, Vice Chairman Washut,
Here.
Representative Yin,
Here.
Representative Swanitzer,
Here.
Chairman Olson.
Here.
Mr. Chairman, you have 8 present, 1 excused.
9. Stay
Okay.
here, Oakley.
You have 9 present.
Thank you, Kay. All right. Representative Wharf, you've got 2 bills in front of us. Which one would you like to discuss?
Mr. Chairman, I was referring to the budget.
HB 140 sounds good to me. Yep, let's do that. Please join us.
Chairman Olson and members of the Judiciary, Representative Ward from House District 49 down on the very southwest corner of the state. I bring before you today House Bill 140. It's titled Expungement for Restoration Rights. I've had some pretty good people that have trained me, and I guess they've always said that we should tell you what the purpose is and what problem we're hoping to solve. And I can tell you that the purpose of this bill is to try to facilitate people, nonviolent felons that perhaps have made a very bad decision. Typically, someone that's younger, somebody that's probably new to the system. The purpose of this is to try to help them get back into the mainstream. And so what problem I'm hoping to solve is to allow these people to have a restoration of rights by being able to have their felony expunged off of their record. And I look at that, I think of an 18-year-old kid that's done something, they've got a felony. This requires them, it doesn't change, really doesn't change a lot, but it does require them to satisfy the judgment. And all we're doing is shortening up the waiting period before they can make that request for an expungement. And the reason that I bring that forward is I look at some of these guys having a felony, they are going to have a hard time. The military won't accept them. So it closes that avenue. They can't get a student loan. So that door's closed. And I'm really trying to break that cycle. You know, they can't get a loan to buy a home. And I look at these young kids that maybe in their late teens made a stupid mistake. And I've had several legislators that have told me that they've had people in their district tell them stories of somebody that has done a stupid thing. They realized it was stupid, but it was egregious enough that they were handed a felony. And, you know, this is just trying to get that monkey off their back. So that is the problem I'm trying to resolve. So with that, I'll go into the bill, Mr. Chairman. And like I said, the first part of the bill, it talks about relating to the criminal procedure, reducing the waiting period, as I said. And this only deals with nonviolent felons. And it just expedites their restoration of rights. It specifies applicability and provides for an effective date. And you can see section 1, it says we're dealing with Wyoming statute 713-1502A, Romanet I, and it says it's amended to read. And I'm not going to read it all for you, but it really all it's doing is it's changing. In Romanet I, like I said, currently it says after you've satisfied all of the judgment for the probation, any restitution, anything that the courts have given you, and you satisfied that, it changes it from waiting 10 years to at least 1 year. And one of the things that I think is important to understand, I know there's some that have said 1 year is not enough time. You haven't proven yourself. And I don't dispute that, but I will argue this case that the courts impose a penalty, and I feel like legislatively we've imposed another 10-year period of penalty. And that's coming from us as a legislative body, not the courts. And all this is doing is it's shortening that period, doesn't obligate the courts to issue that expungement. And the one thing that it does is it requires the person to appear before the judge that sentenced them. So they have to appear, they have to answer for what they've done. And I still contend, if their record is such that you can look back and you can see that they've kind of had chronic problems with the law, that situation, the judge has the ability to look at that record and they can say, I don't know that a year is enough. Come back and see us in another year. They could say, come back in 5 years. The courts can determine the time period that they need to wait. But I look at it, if you're a first-time offender, and granted, it's got to be a pretty egregious violation for you to be a convicted felon. But we're talking about nonviolent felons. And if this is somebody that they just had a bad day, did something that they regret, I really think it's a mistake for our society to flag them for such a long period of time that they can't get this monkey off their back. I know people that have had jobs, good jobs. They've been excelling at it, some of the best employees. When they finally get the background check and they come back as a convicted felon, they're fired. And think about what that does. When you're somebody that's in the system, we got to show them there's a way out of the system. And I really believe that this is my intent, is to try to open that door, create an avenue for not the guys that are chronic. I'm trusting the courts that they're going to catch that. And they're not going to say, well, it says at least 1 year, we have to do it. It says at least 1 year. It's not obligatory. And if the courts want to say, I'm sorry, you got to come back and see me in 10 years, they still have that avenue. But I just think that to make right out of the gate, you got to wait 10 years. I think that's a big hurdle for somebody that has done a nonviolent felony, that's committed a nonviolent felony. But I think we got to have an avenue to open that up. And, there's a whole litany list. I know when I first introduced the bill, I mean, there was some concern that I was just trying to let felons off. And this just applies to nonviolent felons. And I know that there's a few attorneys on this committee, but just to go through, that felonies subject to expungement under this section shall not include. So these are all the felons that cannot get expunged. And that's violent felonies as defined under Wyoming Statute 61104A, Romanet 12. Kidnapping, 62106B. Drug-induced homicide, 62108. Sexual assault.
Representative Worf,
Sir.
let's back up.
Okay.
Let's back up to Wyoming Statute 6-1-104
Okay.
I think this is important for the public listening to the testimony because they keep hearing violent felonies. We're talking about violent felonies within 6-1-104. What are those felonies?
I haven't got them. Well, I think there's a whole litany list of them, but the key is that this is for nonviolent felons. But the thing that the statute only says is it identifies what is a felony, what's a violent felony. A nonviolent felony is just defined as what's not defined as a violent felony.
So 6-1-104 says violent felony, right, is defined as murder, manslaughter, kidnapping, sexual assault in the first or second degree, robbery, aggravated assault, aircraft hijacking, arson in the first or second degree, or aggravated burglary. So those are when you say non-violent felonies, Representative Worf, that's what you're saying is not covered by your proposal for
Correct,
expungement
Mr.
reduction.
Chairman. And that's just to clarify that, because there was initially some concern that I was just letting all felons off, and this does not. This does not apply to them. And it actually, I mean, there's a whole bunch, stalking, child abuse. There's a whole bunch of things that it doesn't apply to. And I
The rest
don't,
of the statutory list, that you're
Yeah,
referencing, there's a large list.
and I don't know that I need to read through all that. Like I said, I just think it's important that people, especially those that aren't here that might be listening, that it does not apply to violent felons. So with that, I would answer any questions that the committee may have regarding this bill. But
Representative Provenza.
Thank you, Mr. Chairman. Thank you, Representative Wharf. This in 7-13-1501 is where the statute deals with expungement of misdemeanors. That wait period is currently 5 years. How do you contend with having felonies, nonviolent felonies, be 1 year and that be 5? And did you omit that purposely in this legislation?
Representative Wharf.
yes, Mr. Chairman, Representative Provenza, I did. When I brought this bill forward, LSO actually suggested that I include the misdemeanor provision. And I told him, I said, to me, the misdemeanor conviction is not as bad of a, I guess, a stigma. I don't know what better word to use, but I think a felony that's what I'm trying to get it at. And, with the expungement of the felony, we're also letting people have their voting rights. They can serve on a jury. They can own firearms. They can possess firearms again. And so, I mentioned bank loans, going in the military. There's a litany list of things, and that's what we're trying to do. And to me, the misdemeanor is a separate issue, and I didn't want to put it in here. I believe there's another bill that you might be aware of that corrects that. And, it's not that I didn't support it. I didn't want to confuse it. When I first brought this up and introduced it, talked to a few of the legislators that I knew, there was some concern. Like I said, I ran into big problems with, initially they thought I was trying to expunge all felons. And so just as a matter, Mr. Chairman, to clarify that, I wanted to stay focused on the restoration of rights. You don't lose rights with a misdemeanor conviction. And so that is why I didn't include it, but it doesn't mean I don't support that action as well. But I think there is a difference between the misdemeanor and the having to carry around the burden that you're a convicted felon.
Clarissa, can you hear me?
Mr. Chairman, I can.
Okay, we lost our screens inside the committee room, so I'm just making sure we're still live on the Zoom.
Okay, yeah, I believe we are still live on YouTube. I'd be happy to call Jamie and get him down to help.
Yeah, could you please?
Absolutely.
Thank you.
I broke the
Follow
video.
up, Representative Provenza.
No, not right now. Thank you.
Representative Wharf. So I think this is a really important question that Representative Provenza is asking. I appreciate the scope of your bill and what your intent was, but wouldn't you agree that it would send, if we didn't adjust the misdemeanor provision, wouldn't you agree that it would send a mixed policy message across the state of Wyoming that if you commit a felony and under our old law, you would have to wait 10 years to expunge, and now we're going to say it's 1 year, and if it's only 5 years for a misdemeanor, wouldn't you agree that would send a mixed message to our people?
Mr. Chairman, I would if in fact this did just set it to 1 year. But as I stated, it doesn't say 1 year. It says at least 1 year. So the court still has the latitude. The court could still come back and say, I'm sorry, you got to come back, see me in 10 years. And I think that's a better decision for the court than our statutes. And so I do agree with that, Mr. Chairman, and I do hope that we can remedy the misdemeanor issue with a different bill. But I did not want to try to to me, that's doing two things with one bill. And yeah, you're reducing the waiting period. But to me, dealing with the felony aspect is vastly different than the misdemeanor. But yeah, for parity, I do agree that we probably need to address that. And I am aware of a bill that is coming forward that I also signed on to. So we will have that opportunity, hopefully, to fix that problem as well, Mr. Chairman.
So Representative Worf, what would be a reason or the reasons that a court would reject an expungement?
Well,
'Cause
Mr.
it seems to
Chairman,
me that you just alluded that it could be time by itself. That's your interpretation of lines 6 through 7. When I read 6 through 7, that's not what I read. I don't read that it says that this is giving a court discretion to say, come back 3 years later because 3 years is a magic number. That's just saying that you can petition at 1 year, 2 year, 3 year, whatever. But the court would have to certainly have some type of finding or reason why it would reject expungement, not just years alone, right?
yes, Mr. Chairman, and that's what I'm saying is we're with this bill, we're giving the courts the latitude rather than putting it in statute, mandating that it's a 10-year wait. We're saying at least a year. And the reason it's at least a year is, and I don't know, but I would imagine that it takes a while for the courts to go through and make sure that judgment has been in fact satisfied. You're having to look at the time that they were obligated to serve, what kind of probation they had, what kind of restitutions. You have to make sure all that was done. And that's one reason why we make it go back to the original court. If Judge Brown's the one that sentenced you, you have to go back to Judge Brown to get this expungement. And like I said, I believe that this gives the court the latitude that if this person has had a series of violations and all of a sudden they finally got pinched with a felony, I don't think the court's obligated to let them expunge it at 1 year. I think they still have the latitude to say the circumstances with this case, the courts may determine that they need 10 years. And I would rather give that latitude to the courts than have it in statute that they're obligated to wait 10 years after they've satisfied the judgment they received from the court. And that's really what this bill is trying to do. Did that answer your question, Mr.
Yeah,
Chairman?
you did. Representative
Okay.
Swanser.
Just thank you, Mr. Chairman. Wanted to clarify and then ask a question. So it's not 1 year after the felony was committed or charged. It's 1 year after they have not only paid whatever their felony term was in jail or their fine, any probation, parole, restitution. So currently it could be a 4 or 5 year process. They could be in jail for 10 years. After that, it's been another 10 years. I suffer sometimes in the legislature now from PTSD because I actually co-sponsored this bill 13 years ago to do the 10-year. And it was a fight like crazy. And all of a sudden, everybody's much more libertarian these days than we used to be around here. But my question that I've now forgot, it's coming back to me. It's not coming back to me right now, Mr. Chairman. I guess that was my question. Make sure it's after they paid. Oh, they paid their time. So here's my concern. And it really deals with the judicial system. It's by that judge. And so you may have some judges in the state, they throw a felony. They may say, I don't ever even come back and see me. The interesting thing would happen would be it's in that court. So my question is, am I correct? If that judge retired, you get a new judge in who's much more sympathetic, friendly. The old judge was difficult, open the floodgates. I guess if we anticipated that, that's what really is intriguing to me about the bill is some judges in Wyoming. And my question overall then is, are we worried about, I guess, the judicial branch interpreting and allowing some people to do this in some districts and others, you're just out of luck?
Well, and Mr. Chairman, that's hard for me to say because I'm not an attorney. I've not spent a lot of time in court. But I can tell you, I've talked to
A good place not to spend time, Representative Worf.
Yeah, I would agree. And I'm counting myself fortunate that I haven't had to. But that's one thing I've been told by the attorneys I know, half the time you don't know what the judge is going to do. I mean, quite often, but I do think there has to be a process. What I assume is if you were in my court in Uintah County and the justice, I'm going to say Justice Brown, sentenced you to 10 years and you served 5 and you was on probation for 3 and you had to pay back $5,000. All that has to be done. And, you know, say Judge Brown has retired now and you got Judge Smith that's now in that seat. I'm assuming that Judge Smith would look at your file that has your entire history of what violations you've had. If we're talking about somebody that's committed a nonviolent felony, that it's a one-off, I would imagine that Judge Smith is going to look at that and he's going to say, well, and maybe he would, maybe he'd be more lenient than Judge Brown, but it's still up to that justice to make that decision. But I also look at it that if you satisfied all that, but you also had a series of problems where you violated your probation and maybe you got caught doing a couple misdemeanor things. To me, if there's flags, I would imagine even if Mr. Smith or Justice Smith wasn't the one that sentenced you, that he would look at that and he would say, well, I'm not so sure that I feel comfortable doing this. And he'll probably tell that individual they got to come back. And that's my guess. But I mean, there's attorneys in this room that dealt with more judges than I have, but I do believe there's a process in place, Representative Zwanitzer and Mr. Chairman, that would remedy that.
Can I-
Follow up, Representative Zwanitzer?
It might be two. One needs to be a follow-up probably to one of the attorneys. Into this section, do you have to go before the same judge or just the same district court that charged you with a felony? Like here in Laramie County, right, we have 4 district judges. You were sentenced by one. You really, I would say arguably, you know, people on the street talk. There are certain judges that are a little more agreeable than others when it comes to how long your sentencing is. Could you go back before another judge in that district and petition a judge specifically, or do you petition the court specifically and then they assign it to one of those 4 judges? How does that work? If Representative Worf or one of the attorneys know.
You got it,
Mr.
Representative
Chairman,
Worf.
I believe on page 2, line 2, and it starts at the back of page of line 1, but it says may petition the convicting court for an expungement. So
Well,
I think
what
you're right.
Representative Zwanitzer, yeah. what
yeah, it
Representative
goes to the
Zwanitzer's-
court, not to justice. That's so maybe I misrepresented that. That's
No, you're right. It's in a different statute. It's 7-13-1401A. And it says that a person may petition the court in which the proceeding occurred or would have occurred, actually, is also key. So,
Yeah.
so you don't necessarily have to wind up in front of the judge. I suppose it depends on the population center.
Yeah. So that's a good correction.
Representative Oakley, did you have a question?
Yes, thank you, Mr. Chair. I have several. So, good morning, Representative Warp.
Morning.
So I guess, first of all, I'd like to discuss what sounds like repeated characterization of what we would, of the crime that we would be discussing here. Bad day, stupid mistake, a one-off. Is there anything in here that can limit what we're talking about to those types of, to a mistake, if you will? Or in essence, does this burden the courts with every single nonviolent felony after 1 year?
Well,
Representative Worf.
and Mr. Chairman, and Representative Oakley, I don't know that I can answer that question. I don't know how many. I was surprised how many legislators responded to this and told me that they had constituents in their district that this applied to. And some of them actually they brought up the misdemeanor and wanted that addressed too. And so I told them that was being addressed in another bill. But I don't know that, but I look at it, whether it's at least 1 year or 10 years, all those people are still hitting the courts at the same time. And by changing it to at least 1 year, that 1 year period, once they've satisfied that judgment, that 1 year period, like I said, it still doesn't obligate the court to act. And they may have more people that are applying for that expungement. I can't answer. I don't know how many, nonviolent felons we have in the state of Wyoming. I don't know that answer to that question, Mr. Chairman. So I can't say whether it would flood the courts. I don't believe it would, but there's more attorneys on this committee than they probably could answer that question better than I could. So.
May I continue? So you just said that they would hit the courts at the same time after 10, and I think I understand what conceptually you're saying, but I guess I would ask you and or say, you've said repeatedly the court, for example, could just say, well, I don't think you're appropriate right now, come back in 10 years. But looking at the bill and looking at the law, tell me where that is that you think a judge would just have discretion to take anybody and say, you don't have the right to apply again for 10 years. In which case we are looking at, are we not, what could be a deluge to the courts. And I guess what I'm looking at, did you talk to any courts or any discussion on what would be the impact? I mean, I'm struck by, we heard the state of the judiciary and from Chief Justice Davis the other day. And I am aware myself, and I'm wondering if you got any information on this about the extreme burden that is on our courts. And when that happens, also, then people don't have access to courts. And I don't see how by definition, this isn't opening it to every nonviolent offender to be going in front of the judges, and that it wouldn't be a burden. Did you discuss doing something? Did you discuss with courts specifically what this might do by having the review of every nonviolent, this opens it up, so every nonviolent felony offense, theft, drug dealers, we could, and I also am interested, of course, in the characterization of felonies as, a bad day and one off. And I've heard that at several committee meetings over the years. Maybe this is a separate question, but I'd also like to discuss what a felony means. It isn't usually, and it shouldn't be, and it didn't go through the courts as such, as a bad day. So both questions as far as what this would mean to the court system, and then and also if there's any way to limit this in that way.
Mr. Chairman, your first question, I haven't talked to any of the, I haven't, but there may be other people in the room that have, so that may be a question that somebody else can answer. I can tell you, I have not talked to any of the judges or any of the courts. But I guess to me, we're talking about a policy change here, going from requiring a 10-year waiting period to giving them at least 1 year to where they can petition the court. And I still contend that it's not going to be a flood, because the waiting period has gone from at least 10 years. If we pass this, goes from at least 10 to 1 year, and you still have to satisfy your judgment. You do have to do your term. So, I don't know currently, because there is a thing, if you look under Section 2, it does say a person convicted of a felony or felony subject to expungement under Wyoming Statute 713-1502 before the effective date of this act is entitled to expungement under the time frame provided by this act. Now, that means people that have nonviolent felons, and there could be a bunch. I don't know that. But I think from, the effective date of July 1st, 2021, if that becomes the effective date when this act becomes law, I think you're still going to have it staggered, because all these nonviolent felons are going to have to satisfy their time served, their probation, their judgment. All that will have to be satisfied. And I'm assuming that not everybody that goes to court gets the same penalty. It's the same time served, whatnot. So I don't think that's going to be an issue. It may be an issue, like I said, under section 2, where it applies to those that have a nonviolent felony before, because it does open the door for them. And so it could, but I still contend that it's a better decision, I think. And I didn't realize that it was one of the members that actually played a role in putting the 10-year wait on there. But to me, that's what we're trying to do is remove that period. And I don't know if that answers your question, but like I said, somebody else could have talked to the judges. I have not talked to the courts, Mr. Chairman. So I can't answer that question.
Representative Worf, I learned that lesson when I was a freshman too. I brought a bill and lo and behold, it was something, a decade ago that Representative Zwanzer had worked on. And that's what happens when you've got a guy who's longest serving member in the House.
And Mr. Chairman, I don't know, Representative Oakley, did I answer all your questions? You threw a couple of them there, and I don't.
Well, here's what I'm going to do, Representative Worf.
Okay.
The more that I stew on this and the more I think about it, the more I look at what I wasn't fully aware of, but you alluded to in your testimony, which really made me aware of it, was the reality of expungement bills. It's a sexy topic for the 2021 general session. So as I look through, I see multiple expungement bills, but yours is the only one that's been read and referred to my committee. So what I think I'm going to do is I'm going to open it up to public testimony and take some public testimony on it. What I'm inclined to do is lay your bill back so that I can have all the expungement bills in front of us all at once. Because of where this is headed on a few different instances has been, so example, the misdemeanor and the felony comparison. I can't predict what one bill is going to do versus the other bill. And then in reviewing other bills, what I now see is that we actually are amending some of the exact same statutes in different ways. So that can cause obviously complication if we have multiple bills going through the session, as doing that.
Yep. So
I think what the most prudent thing and judicial thing to do with that is to get them all in front of me at once. I'm not even certain what the speaker has that he's going to read in, but I have a good feeling, because there's a big stack coming in today, that we'll be able to get them. So my goal would be that we can finish up Monday with all of the expungement bills in front of us at once. Do you have any issues with that idea?
Well, Mr. Chairman, I don't, other than the fact that this is the bill that's been introduced, that's the expungement bill. And quite frankly, and this isn't a criticism, you all know I'm a freshman, but I've had two different bills that the expungements one, I have another one that's in revenue, that I don't understand why LSO didn't tell me that there were other expungement bills. Because my understanding is if there's a bill that's similar, we're supposed to have the opportunity. I was never approached. I mean, I did talk with Representative Provenza about the misdemeanor aspect, but that's the only thing. To me, LSO didn't mash them all together. And I don't know
probably
why.
The first out the gate, Representative Worf.
Well, and I have no idea. I just know that oddly enough, I'm the one sitting before your committee, but
yeah, by I think 100 and looking at the numbers by 130. So I think,
Okay.
what happens there is if you're the first one out the gate, then what our legislative service office does is inform representatives who are coming in that may have a similar idea. They don't necessarily inform you, they inform the new representative.
Okay.
And they say, hey, there's a bill out there that looks like this. Why don't you contact so-and-so? And then if that representative doesn't reach out to you, that's how we end up with multiple bills. So
Well,
I don't
appreciate-
think there's anything wrong with the process or the legislative service office in this instance. It's just, it's just maybe they got a lot of it looks like they're all freshman bills.
Yeah.
So freshmen just haven't quite figured out yet how to figure out who's running what, but that comes, now we're starting to learn what happens when that happens.
Well, and Mr. Chairman, I'm going to defer to you. You're the chairman of this committee. I do know there's other people here that want to testify,
Right.
Probably both for and against. And I think it'd be prudent to listen to those. I know some have traveled some distance to be here
Yep.
today.
That's exactly
but
what I was
I'm
thinking.
going to follow your lead, Mr. Chairman.
Thank you, Representative Worf. I remember you telling me that I think that was going to be a possibility. So that's why I cut off questioning from the committee. because I want to get in the public testimony for the people that you've brought here to testify. And then I just want to take all the expungement bills at the same time.
Okay, and I'm comfortable with that, Mr. Chairman.
Okay.
Thank
Very
you.
good.
And
So
and
who
I-
is your, who are your witnesses?
Well, I know that former Senator Kit Jennings has come down. He would like to address the committee, and I don't know, Representative Burt was also a co-signer. I don't know if he has anything
He's right
to
down
say.
the hall. We can get him in here anytime we need.
Well, and if he wants to say something, he will say something, so.
Representative Swanson.
Just need one question, because ultimately the issue is constitutionally, we can't probably amend a bill into years because it's written too tightly, where we could amend yours into another. But I want to make sure you're okay with amending the misdemeanor section as well, lower. Because if you're not, then I will have a different vote on the motion, but.
And
You're okay.
Mr. Chairman, like I said, I'm a biologist. You know, there's more attorneys in this room than I've ever dealt with in my life. So I am going to defer to you guys. I can tell you that was the reason I kept the misdemeanor out. It wasn't that I didn't agree with it. I thought it confused the issue. If you guys think that it makes more sense to combine them, I've signed on to Representative Provenza's bill. I don't know if there's any other dealing with misdemeanors. That's the only one I'm aware of. But if this committee decides that it makes more sense to combine them, I have no problem with that action, Mr. Chairman.
Okay. Well, yeah, thank you, Representative Swanson, because that's exactly where I'm at. I support this bill. I support what you're trying to do, but I'm also a co-sponsor of 212. I support what that bill's trying to do. And as I've been trying to figure out, in your bill, whether intentionally or not, is written very tight. So I came to the same conclusion Representative Swanson did. I want to address the misdemeanor provision at the same time. And we just got to figure out the vehicle to do that. And if you're amenable to that, I think we can figure it out.
Yeah, I have no problem with that. Like I said, I'm a biologist and I'm carrying this bill because I have friends that ask me to. But I look at it. If this committee thinks that's the wise and prudent thing to do, I'm going to defer to your wisdom. You guys have more years than I have. So
Okay.
I appreciate the opportunity to be before your committee. And as you know, I'm here. If somebody thinks of a question, you can pull me off the floor anytime and we can talk about it. So,
All right.
thank you, Mr. Chairman.
Don't go anywhere. You got more bills coming up. That's the other thing
Yeah.
I'm trying to do. I'm trying to get to your.
Yeah,
other
and that's
bill.
it. I took more time than I thought we'd have.
That's why I let you pick the order.
Well, and that's the one I wanted to do.
Maybe you
first.
should have picked the other one
No,
first.
well, it would have maybe been quicker. I don't know. We'll see.
There was a secret to my question. I asked which bill, not which order. I said which bill. Because I had a suspicion that you may only get to one. But that's a lesson we'll figure out over time too. We'll get there. We'll work them hard. Okay. Representative Burt.
Morning, Mr. Chairman, ladies and gentlemen of the committee. Thank you for your time. I am a co-sponsor on this one, as well as Representative Provenza's as well, that will come up a little bit later. I just want a couple quick comments since I am on a support of this one. I do believe have to voice our views on this one. I do believe this one is kind of a lot. It does address a lot of different issues, but where I'm at on this one is going back to a question of the burden of the courts on this one. The current system, if our nonviolent offenders are not able to pick out the loans or go to school or to be able to basically rectify, the bad choices in life and be able to make a better move forward and better themselves, they'll put themselves into a repeat offender offense. How many times do they go back to the courts, and what kind of burden do they put on the courts at that point in time? If we can address the issues, the couple of questions that we have on this particular bill, and we can get those nonviolent offenders out of the court system, then we won't see them as repeat. One, we can allow them to better their life, they become better citizens in the community, and overall, without being repeat offenders, we can actually remove them from the court system, overall reducing the burdens, not only the correction system, but also the court system. So I do think, I am in favor of this bill, and I think passing it, with where it has to be within the statutes, would actually reduce the burdens in our systems and stuff like that. So I do want to offer my support on that. I do believe as a society that when we commit to rehabilitation of those that have gone into this particular life, whether it's by their, no choice of their own or by bad actions, I think we need to follow up on that commitment and not brand folks that have paid their debt to society with that scarlet letter. So I think we can reduce the recidivism and actually support the rehabilitation. I believe this bill actually pushes our state to actually do that. So on in support of it. I thank you for your time, Mr. Chairman.
Thank you. Questions for Representative Burt? Representative Oakley.
Yes, thank you, Mr. Chairman. Representative Burt, again, you mentioned that it would reduce burdens. My question, did you look or have you looked at doing this another way statutorily? Because my question would be, if we're going to have restrictions for what felons can do or not do, really, and then we're just going to turn around and say, come back to the court and ask for that to be lifted in a year. Isn't really what you're getting at that you don't want nonviolent offenders held to the restrictions of felons? And if so, did you just look at doing that? Because and I'm seeing some, if that's really where we're getting at here, I cannot see the logic of going through the court system, convicting somebody of a felony, which also means that they did not evidently get a deferral or some other, or a misdemeanor. It means the courts and the prosecutors and the jury decided they were guilty of a felony with no deferral process. But then we're coming back in a year. I mean, is this really the vehicle that you're trying to get at if we're not going to, if we're not going to have these restrictions for nonviolent offenders? I mean, and is there another legal avenue to really get at what you would like to get to?
Representative Burt.
Thank you, Mr. Chairman. Thank you, Representative Oakley. I kind of have to repeat the sentiment from Representative Worf. I'm not a lawyer. I'm a railroader. And I myself have not spent a lot of time in the court system, and I don't understand how that whole process works. I do believe my understanding of it is that when a judge gets to, and again, correct me if I'm wrong, please. My understanding is that when the sentencing comes down, the presiding judge has the ultimate ability to determine what that sentence is, regardless of what the court has recommended. Am I right or am I wrong? Again, correct me if I'm wrong on that. If we leave the ability for the judge to make the final sentencing of that, why would we not allow the judge, after a year of the finish of that sentence to be up, why would we not want to give the judge the ability to go back and relook at the whole thing as an overall determination of whether or not the sentence, the sentencing measures were met. So if we're going to say that, a judge can't figure out whether or not a nonviolent felon, conviction, that individual hasn't met their sentence and completed their basically paid off their debt to society, then why would we give them the ability to determine which sentence it was in the first place? I think our judges are smart enough to look at everything as a whole. And if a nonviolent felony conviction is a year out, and the judge looks at that and says, "This is what I require you to do to pay your debt to society," and I pay my debt to society, and I go back in front of the judge and I petition to have my record expunged, have I not met the requirements of the courts? I mean, that's what the judges tell me I have to do to pay my debt. Why would I not be able to have the ability to go back and say, I've paid my debt as you've asked me to do that? Now, if I don't pay my debt or I continue along the path, then I would imagine the judge would look at me and say, "Mr. Burt, you're coming here, you're asking me for, basically to forgive your conviction, but you haven't met what I've asked you to do. It's got to be a partnership in a way. The courts require the convicted to meet a sentence. If that individual meets that requirement, then we should be able to give back to the judges to determine whether or not that was met. I don't know if I've answered your question, but that's where I think you're trying to lead me in your question. I'm not sure.
It's an answer, nonetheless. Representative Oakley?
Nothing further, thank you.
Looks like you got it. Representative Craig.
Mr. Chairman, thank you. Representative Burt. And this isn't necessarily a question just for you, but for anybody who has already testified or may testify or in preparation for our next go round of this whenever it comes, because these are some questions I'm thinking in my head that I think we need to answer before we move forward on this type of legislation. One of the reasons I think in my head as a practicing lawyer and do a little bit of criminal work, but not near as much as Representative Oakley, is the 10 years provides a period in there, what I'm gonna call a look back period, right? You've proven to society that you can keep your nose clean. And so we have judicial resources that are scarce, and most of our judges are overworked and don't have a ton of time to be handling extra hearings as it is. And so the 10 years, yes, and that might be too long. I'm not saying it's not, but what I'm getting at is I think 1 year is too short. And one of the reasons I believe that is you commit a felony, you make it a year, you go get your expungement. We've spent, however many hours of legal time, both in the county attorney's office, both in the judge's office, and we've decided, yep, you met the requirements under the statute, you're entitled to an expungement, and 3 months later you go commit another felony. Okay, and now if we had waited 3 months, you wouldn't have ever been able to get an expungement, because under the statute, once you've committed a second felony, you're not entitled to expungement of your record. So my question is, do we have stats? What's the recidivism rate? How often do felons commit a second felony within 1 year? How often is it within 2 years? How often is it within 3 years? Where's that balance, right? If how far do they typically make it before we know that they're not going to commit a second felony? And that's a question I'd like answered as we go forward, because I think that'll help us figure out where that line is, where we can say, yep, if you've made it 3 years, you're probably not going to commit another felony, and it'd be a good time to look at going through the expungement process and spending that time. And then the other question I have is sort of a judicial process question, and I don't even know the answer. Reading the statute, it's not clear. And this goes to Representative Worf's testimony. I'm not positive under the statute that once you've filed that petition and it has been denied by the judge, whether you can bring another one. There's a legal term called res judicata, collateral estoppel, whatever you want to call it, that says once you've brought a particular claim or filed a particular petition, you're not allowed to do it again. And so that's something else we need to look at, because I'd hate for these guys to, or gals, someone to bring a petition within 1 year, and then the judge says, "Now, I think you're going to have to wait a while." And then lo and behold, the prosecutor 5 years down the road says, you already brought you had your one chance, you lost it, and you're never entitled to expungement again. And so that's just something I think we need to look at and clear that up, because in my mind, reading the statute, I think once you've brought the petition and it's been denied by the judge, there's a pretty good argument by the prosecutors that you would not be entitled to do that again.
Well, Representative Craig, I think the first part of your question, I doubt Representative Burt has the Wyoming data in his head, but part of what I realized, and I'm realizing even more now, is there's a particular actor who's not here today that would have the answer to that, and that's the Department of Corrections. So Department of Corrections, if you're listening, when we carry this bill over to Monday, we would love for you to be present, and we'll shoot out an email to make sure we get an invite out to you. But I think those questions would be best, so we're not just guessing. We can get the answers to those questions. And then as far as the other legal question, I don't know if so far I don't think we have any when we have prosecutors on this committee, but normally I would take testimony from a prosecutor to give me the answer to that, Representative Craigo.
Thank you, Mr. Chairman. And I didn't expect Mr. Representative Burt to answer those. I just wanted to get them out there because I think those are some questions like I said, we need to wrestle with
Right.
and find the answer, because there's probably a balancing point in there somewhere that it does make sense. But I'm just sitting here today. I don't think it's 1 year, because just knowing what I know, the little bit I know about the legal system, that I'm not sure that's it. But it's a good conversation we need to have.
I appreciate your questions. We'll definitely get them answered. I just already know Representative Burt's answer. I'm a railroader. And that's okay. There's nothing wrong with that. Just don't expect you to have to answer the question that you may not have an answer to. So.
Mr.
Did you have a
Chairman,
response, Representative Burt?
I just have a response, Mr. Chairman. Representative Craigo, those are good questions. And you'd have to kind of really look into the data, and we let the department that deals with that work on that. But, just on a personal note, I mean, I don't visit the courts. I don't have a reason to. It's not my lifestyle. I don't get to that point, right? But if I were to fall on this as a nonviolent felon, convicted nonviolent felon, I think you would have to look at my past history. Where have I been? What have I done? Have I had anything that led up to that to I guess kind of determine whether or not I would have a case in the future to look at that. And I think that's where those judges would look at and have those cases and stuff like that. And I think where the intent of this bill was supposed to be at was those individuals that don't lead a life of crime are the ones that we're trying to address. We're trying to get them back into society and let that happen. So no, I don't have those stats and stuff like that, but I'd also think, like I said, this isn't, we're not looking at, normal violent felons that all of a sudden had a nonviolent felony that's trying to work this out. It's those that don't lead that life of crime. So the stats could alter depending on our background history, but thank you for the question.
Thank you, Representative Burt. And if the stats do, what I find really interesting is that the two government prosecutors are the ones asking if it's going to flood the system. And I thought that would create job security, but maybe that's not what we're worried about. Thank you, Representative Burt. The Honorable former Senator Jennings.
Thank you, Mr. Chairman. It's an honor and pleasure to chairs of the desk a whole lot better.
You're welcome to stand, but I wouldn't recommend it.
I would like to throw a different twist. And I'll try.
So Senator Jennings, something
Oh,
that.
My name is Kit Jennings. I'm from Casper, Wyoming.
Yep, and the mic has to be lit because now this is a little bit different than when you testified in this.
It's green.
Beautiful Capitol, and now the camera. When you light that, the camera comes and looks at you. So if we want to see you on the YouTube, you have to make sure it's lit.
I have to make sure it's lit and behave myself.
Go ahead.
Okay. I would like to come back around and look at some of the questions that were asked because I have done some of that research. But before I do that, I'd like to throw another twist on the table here because I was hanging around when the mandatory minimums and all that were being argued way back when. And when I was back in that part and looking at that, remembering that, it kind of, I had to go back to the Constitution and really dig to the Constitution to have an answer for myself. And I was in that same group as the honorable representative on your committee was, let's nail them. Let's put it to them. Let's make sure that this never happens again. But if you go into our Constitution in Article 2, Section 1, and the powers of the governor of the state are divided into three distinct departments: the legislative, executive, and judicial. And no person or collection of persons charged with the exercise of powers properly belonging to one of these departments shall exercise any powers properly belonging to the other department. Well, on the judicial side, the relation that the legislature and the judiciary should have is the legislature should create the rules and the tools that the court needs. And I think for the most part, that has happened since the state started and the Constitution was there. But as we get to looking at the minimums and the mandatories, which this 10 years is a mandatory sentence, it's part of what happens, is a sentence that's put on by the legislature. It's also agreed to by the executive branch because they have to sign that into law. But then you go back and look at over time, what happens? A lot of times these people, when we come over here, the judge is not going to come back to us and say, I don't want this. But I can tell you, I've watched a young man do this. He went to Colorado. I just read you. This is not exactly word for word for what happened to this young man, but he give you an idea. He's 20 years old. Drove to Colorado and bought marijuana. It's legal in Colorado. But when the trooper pulled him over in Wyoming, he found out that that wasn't legal. So he was 20 at the time. 21 years old, he finally got to court and found that having a felony amount, 16 ounces, got him the felony. He didn't really have the best lawyer in the world, but he had a lawyer, and the lawyer said, plead guilty, and we'll get you off on probation. So he pled guilty, all except for one. They argued about. Court said, young man, you've pled guilty to all these counts. You pled guilty to your girlfriend's counts, so we're going to give them to you, not to her. And they laid a mandatory drug rehab and 5 years and a fine. So I threw $5,000 in for court costs and fines, and I did that because it's more than it probably was, but it makes for good discussion. So at 22 years old, this young man has completed the drug rehab program. And because of the felony on his record, he can't find a good paying job, and he's only paid the court $350 out of that $5,000. At 23, he still can't find a decent job because every time he goes to a job that requires a credit check or a background check, the felony pops up. This young man in particular would have jobs. They would take him and he would be working and he would be doing well. His supervisors liked him and everything. The background check comes back and they release him. So at 23 years old, he's paid 1,000 of the 5,000. The 24 job things, about what it's always been. There's a felony there, and so you're not going to get one that you're going to get advancements in. You're looking at service jobs in the fast food restaurants and stuff like that. But even those, we had quite a move in Casper at one time where one of the fast food restaurants checked your background, and if you had any kind of a bad background, you didn't get to work there. So at 26 years old, drug rehab is finished, the probation's finished. He still owes $1,000 to the court. So he's still within that time that he can't do anything for expungement. At 27, he's got the court paid off. He's 37 years old. He's had the felony on his record. He's lost several education funding grants because of the felony. He's been released from 12 jobs after the background checks were returned. Now, this part I just added because I did the research. It didn't happen to this young man, but he was turned down for most any job in the Army, Navy, Air Force, and the Marines. And he's turned down for 2 home loans and refused by several apartment complexes that rent an apartment. Now, this comes back into kind of answer some of the questions of what happens when you're eligible to go for this after the 10 years. In 10 years, you have to behave yourself. You don't find a good job. You could look back at your friends who are currently driving to Colorado, buying marijuana, sneaking it back into the state and reselling it, and the amount of money that they're making. But this young man stayed away from that. He has to raise about $3,000 to pay an attorney to write a motion that costs $300 to file to the court to ask the court to examine his expungement. So when you think that there's going to be a flood of these people coming in because we've moved this at least 1 year back from at least 10 years, then you have to realize these are people that probably don't have a high paying job unless they stumbled into something in the oil and gas industry or something that just needs their muscle every day and that's it. But even that's up and down. And currently that's down. So you get the lawyer fee, the filing fee. And when the judge gets it, the judge has several options. And going back to can you do this one time and then you're out? The judge can look back at the record and he can ask for additional information. The prosecuting attorney can come into the deal if he wants to and talk to the judge. The judge has the motion in front of him. The judge is not required to have a hearing. The judge can decide right there, I am either going to do this, I'm not going to do it, or I want a hearing and I want to bring all the parties in and see, do the attorneys in this case agree? Should this young man, well, at this point, this 40-year-old guy have his felony expunged? What good's it going to do at 40? Well, some people can go back to college. Somebody can be retrained. Somebody can get back into the system that way. But what we have to look at is we're doing all of this and we're putting it together. You guys have to decide, why are we doing this? What is our ultimate goal? Punishment is the infliction or imposition of a penalty as retribution for an offense. You screwed up and you're going to pay for this the rest of your life. And you're going to be the example that we're going to set for anybody else that would even think, could I get away with this? Or rehabilitation is the action of restoring someone to health or normal life through training, therapy, after imprisonment, addiction, or illness. Rehabilitation is an act of restoring criminals to a proper state so they can be active participants in society upon completion of their punishment. You guys have to decide which are we addressing here? Are we addressing punishment? Or are we trying to rehabilitate our citizens and get them back in to where they're taxpayers and they're voters and they have their Second Amendment rights? When you go back and look at the non-delegation doctrine, and we as legislators, you as legislators, look at this 10-year or 1 year, it says at least that judge has the opportunity, if he pays attention and he's a good judge, which I hope they all are, because our judges are either appointed by the president and approved by the U.S. Senate, or appointed by the governor and approved by the state Senate. So these are people that have been researched. They should be smart enough to know the law. And I know that some of us would disagree with that in certain cases, but that's what we have to assume. I have one letter, or I have several. I sent some letters out and kind of made my pitch on this. And I had worst case instances come back to me. One of them, I remember what happened with a nonviolent felon that killed somebody. You can't there's no way that you can figure out if I take this guy's felony away from him, if I had left it there, would he still have gone out and committed another crime? I would say that when you finally get the numbers in here and look at the repeat offenders, if they still have the felony under them and they're not being rehabilitated, they're only being punished, chances are they are going to commit another crime because they can't find a decent job. It's not there. I've watched it. So when you talk about the misdemeanor part of this, Mr. Chairman, I don't think it's that hard to fix your question on the misdemeanor. I see a whole bunch of bright committee members right there that could put an amendment on it today that would just add the misdemeanor in there and mark out the 5 years and put 1 year in there, and you fixed it. I've looked through the statutes. I've tried to figure out, is there a better way to do this? I've read the statutes, and this is about the best way you guys have to do it. this is simple. You strike a number out and you put another number in there. You tell the judges, you have the right, just like you have the right to convict somebody without the possibility of parole, you have the right as a judge and the responsibility to evaluate this case and this criminal and determine whether or not he should wait 1 year or 10 years. This could be part of the sentence, and it should be, because as a legislature, again, your job is to give them the boundaries and to give them the tools, but not to put the sentence on every single person that has a felony. Most of these people that are coming in on this nonviolent felony is drugs. They messed up. They were young and stupid. And I know that that's probably things that we don't want to really justify changing the statute over, but that's what they were. They were dumb. And this 20-year-old kid is going to stay dumb all his life. Thank you, Mr. Chairman.
Thank you. Questions for the former senator? Thank you.
Thank you, Mr. Chairman. Thank you for your time.
All right,
Mr. Chairman,
Clarissa.
Chelsea McMichael has raised her hand on Zoom. I can admit her to the meeting if you'd like.
Oh, yeah, please do.
She has joined the meeting, Mr. Chairman.
Hi, can you hear me?
Yeah, Ms. McMichael, go ahead and introduce yourself for the record and then give us your opinions, please.
Okay, my name is Chelsea McMichael. I am a former Wyoming Women's Center convict, and I've completed all of my necessary probation and parole. So I have a testimony for you guys, and I hope that you can listen. So I was a drug addict for 12 years. In 2013, I knowingly and willingly possessed heroin in the amount of 1 needleful. Because this weighed a felony amount, and due to my underage consumption, this answer for Ms. Oakley, because I took a deferral in Utah when I was 18 for drinking alcohol, I was unable to get my deferral here in Wyoming. I was not eligible for a sentence deferral, although I'm extremely grateful for my time in the Women's Center. I feel that I've served my time and I've contributed an extreme amount to my community. However, according to current law, I must wait yet another 5 years to be eligible for expungement. I was a Girl Scout troop leader. I appealed to do that for my daughter. I'm a parent policy council member through Head Start here in Sweetwater County. I am working on this political affiliation stuff for probably a good 7 months now. I'm a nonprofit member. I've worked in Sleep in Heavenly Peace. The list goes on, but my point being is that I'm not the only one who has completely changed their lives around due to the fact that they got such good substance abuse and mental health treatment while in the Wyoming Women's Center and while on parole. So that's kind of my point. I pushed for my representatives and senators to take on the amending the current law 713-1502, because I and many other felons have completely changed their lives around since incarceration. And I feel that we deserve a second chance without having this label on our backs. It's not reasonable for the second chance to take 10 years, which I feel at the time, I feel like you made the right decision for what was best for Wyoming. However, at this point in time, I don't feel that it is reasonable. States around us, such as Utah, who has a 3-year, 5-year, and 7-year expungement process, are much more lenient. And not only does Utah have more leniency in the years that it takes for expungement, the Salt Lake County Mayor's Office of Criminal Justice Initiatives had a free legal assistance with Utah Criminal Records Remote Expungement Day just on Tuesday. So I understand that they have a lot more resources than we do to get expunged. But they also make it a lot more lenient. And not only does Utah, but red states as well. They, in 2019, 23 states changed their expungement laws to make them more lenient. Wyoming did so, but with the juvenile system, which I completely respect. When you're a kid, you don't, completely understand what you're doing. When I committed my crime, I was 24. However, I'd been a drug addict since I was 12 years old and never received the help that I felt like should have been available to me. So there's my personal testimony, and I just have a few answers to some of the questions that have been asked in this meeting so far. So sorry, I wrote them all down. So the substance abuse treatment completion for parole in 2019 was 79%. The cognitive behavioral completion was 72.2%. The sex offender treatment completion was 61.3%. And the employment training program was 93.8% completion. However, it is completely difficult to get gainful employment when you have a felony on your record. I can't work at the mines. I've been applying for job after job after job in order to get an income increase, and I haven't been able to do that due to my felony. There were some more, and then the biggest question, I feel like, with your recidivism question, I do have an answer for that. Inmates who did not return for new felonies was 92.3%. And I'm getting this off the WDOC 2019 annual report. So their primary functions of the Department of Corrections are public safety, rehabilitation, case management, correctional standards, good stewardship. And they do these risk assessments to place us in the type of treatment that we need in order for us to be successful after being released. I feel that out of all of the women that I was in treatment with, I want to say at least, and this isn't accurate, but from what I know, at least 90% of the women that I know who have been released with me, they haven't committed crimes again. They haven't gone back to prison. So the recidivism rate is pretty low. Actually, Wyoming's recidivism rate is only 23.8%. We are the second lowest in the nation. This number is also from 2019. The last one in the nation is actually Oregon. So we do have a really low recidivism rate. I feel that, when it comes.
Ms. Michael, can you go ahead and, I'm sorry to cut you off, but I need you to wrap it up.
Okay, yeah. Just to let you know, last thing, when you do have to be on parole, you do have to complete more treatment. For one, you do have to complete community service, and you do have to have gainful employment. So, and that's ongoing, or else you do get returned back to jail. So thank you. And that's all I have.
Michael, and I really appreciate you sharing your story and sharing your testimony. And, this afternoon, you might like this, so you might want to join us at noon. This committee is actually going to be receiving a report from CSG on justice reinvestment. So I think a lot of the numbers that you're talking about, we're going to be intimately talking about. That's why I cut you off. Not because I wanted to steal your thunder, but all that's coming to this committee in good time. And I have other bills that I got to get to as well. So we really appreciate your testimony, Mrs. McMichael.
Okay. I appreciate it. Thank you.
Thank you. Questions, committee? All right, so I think that concludes the testimony that I'm concerned about getting in. Again, I'm gonna lay this bill back, so we're gonna move to another day where I know there's more testimony on the bill. So I just know that the actors that I know that want to testify, I know you're here every day. So I know I'm not gonna miss you. And so I'm just trying to get in some folks that traveled and accommodate some schedules. So I hope that's okay with everyone. And I just think it's the right and it's the fair thing to do. It's not my fault that the bill didn't get, the 212 didn't get read in and referred to me. And I guess I didn't realize there was so much similarity. I understand Senator Jennings's position that you could just simply amend it, and I appreciate that. But then you got two bills that do the same thing, and I don't think that's fair to the other author of the bill either. So I'm going to hear both bills at the same time. So committee without objection, I would lay this bill back. And with that, let's go ahead and take up House Bill 153, Representative Stiff.
Mr. Chairman, members of the committee, thank you. I present to you House Bill 153 and request your favorable consideration. This bill the idea for this bill was brought to my attention by a number of the circuit court judges in the state. They have had difficulty and contemplate having difficulty complying with the governor's request to cut their budgets by 10%, and then on a biannualized basis going forward, another 10% under the step 2 and step 3 budget cuts. And the reason the circuit court judges are having difficulty cutting their budgets is because that unlike other state agencies, the court system, circuit courts, for example, they don't have a lot of overhead expenses. Their buildings are provided by the county. So their budgets are a very high percentage of the judge's salary. So 90% of their budget is in salaries, for example. So when it comes to magistrates, the feeling is that the improvements and the investments in technology across the state to allow for video presentation, video hearings and the like, allows the circuit court magistrates to cover for each other, to allow that the technology allows them to be a little more efficient. So the choice the judges face is, do they, to make these budget cuts, where do they go? Currently, there are some full-time circuit court magistrates, and under our current statute, you can create full-time circuit court magistrates, but it's a one-way ratchet. You can create them, but you can't get rid of them. So once they get created, they just last forever. What this bill would do would be to give the Supreme Court the authority to review whether any of the existing full-time circuit court magistrates could be eliminated. That is, are they unnecessary? This bill does not mandate that the Supreme Court take such action. This bill does not eliminate directly any full-time circuit court magistrates, but it would give the Supreme Court the authority to do so. And so this would provide another tool for the Supreme Court to try to achieve efficiencies and to achieve budget cuts without furloughing circuit court judges, because the alternative is to tell the circuit court judges, well, we're going to have you take off 2 days a month, for example, and so we're just going to pay you less than your salary, which raises its own problems because it's unclear whether that's actually lawful to do, to pay a circuit court judge less than their statutory salary. But that's in fact what the circuit court judges have been doing, is my understanding, is they've been furloughed to some extent to try to get their budgets down. So I apologize if that was so walking through the bill, the meat of the bill, I believe, is on page 3. The new language, new subsection C in the relevant statute provides that before any appointment or reappointment of a full-time magistrate for a full-time magistrate office, and after consultation with the appropriate Board of County Commissioners, the Supreme Court shall review the need for the full-time magistrate in the affected county. So there is at least a consultation process so that the rug wouldn't be ripped out from underneath the Board of County Commissioners without notice to them. As currently drafted, it also would only allow for the elimination of these magistrate positions as their terms expire. That is, even under this process, if a magistrate has been appointed to a 4-year term, it would not be terminated early. It would just, they might just not reappoint to that position. So with that perhaps overly long explanation, Mr. Chairman, I would stand for any questions.
Committee. Representative Craigo.
Thank you, Mr. Chairman. Representative Stiff, I just wanted, so you testified that the Supreme Court cannot remove a magistrate at this point unless we change the statute, but the actual circuit court judges of that circuit could remove the magistrate. Is that right?
Representative Stiff.
Mr. Chairman, Representative Craigo, you probably know better than I about that. It's my understanding is that once a person is appointed, it's sort of set in stone. I'm not aware, let me say it this way, I'm not aware of a full-time magistrate position once having been created has ever been eliminated. I'm not sure that's ever happened.
Representative Craigo.
Mr. Chairman, Representative Stiff, thank you. So I was not aware of this. Actually, I was just, if we look at the bottom of page 2 of your bill, it says irrespective of any vote of the electorate whereby the magistrate is retained in office, the circuit judges of the circuit by unanimous vote may remove the magistrate. I didn't know that existed, to be honest, in statute. So that was news to me in reading your bill, but.
Mr. Chairman, Representative Craigo, that is an existing law. And I suppose if were this committee to vote this bill down, you could always throw it back to the circuit court judges and say, hey, if you really want this, you can by unanimous vote, boot somebody.
The circuit court could unanimously boot their magistrate, but not the Supreme Court.
Strangely, that's correct.
And not the county commissioners.
Which appears to be an anomaly in the law.
Mr.
Well, I know how laws are made. So I'm not that surprised. Representative Craigo.
So, thank you, Mr. Chairman, Representative Stiff. So I'm just curious if this is, I mean, what the goal, if we can already remove the judge for any reason why the circuit court judges are requesting the language, why the responsibility be shifted to the Supreme Court. Thank you.
But before you step into that, Clarissa, do we have any circuit court judges by Zoom?
Mr. Chairman, I do not have any attendees by Zoom currently.
I really thought I would see Judge Christensen. Judge Christensen. Maybe if we say his name enough, he'll show up.
And
Representative Stiff.
Mr. Chairman, I did extend a personal invitation to Judge Prokos in my circuit to alert him of today's meeting at this time, but then they're very busy people. They have jobs, and so they may be in hearings. To respond, if I may, Mr. Chairman, to Representative Craigo's observation, the existing language at the bottom of page 2 and top of page 3 states that irrespective of any vote of the electorate whereby the magistrate is retained in office, the circuit judges of the circuit by unanimous vote may remove the magistrate. Okay, so this means that the circuit court judges in that circuit could do it, right? But what's their incentive to do it? This magistrate is helping them, right? And it's my understanding that
A problem child. This would be a problem child, not that they, I read this more as maybe remove and get a new one. Not just get rid of a magistrate entirely because it says in the beginning of the sentence, if I was to pretend to be a judge and apply what was the legislative intent, irrespective of any vote of the electorate you would assume would be the ones who would retain and not retain, right? So I think it's contemplating we've got a bad egg and we want to get rid of them, not get rid of a magistrate position entirely. Would you agree, Representative Stiff?
Mr. Chairman, I would agree, and I support the bill and bring it because I believe it's important that the Supreme Court have the authority to administer the judicial branch.
Vice Chairman Washit.
Thank you, Mr. Chairman. Representative Stiff, thanks for coming this morning. How many of these full-time magistrates do we have and which circuits are they located?
Mr. Chairman, Representative Washit, I believe Representative Crago could probably tell you more precisely, but they are located mostly in the northeastern part of the state. There are just a handful of them. For instance, I do not believe we have any full-time circuit court magistrates in the southwestern part of the state. And so Representative Crago probably can give you the best sense of how it works on the ground. It is my understanding that these full-time circuit court magistrates work hard, provide a valuable service, and the intent is not to cast any aspersions on the work that they do. That's not the intent here. Rather, it's to give the Supreme Court the tool to review this, make decisions as appropriate.
Representative Stiff, I don't want to entirely thrust this question on you because it's not entirely fair, but because I don't have at this moment any testimony from the Supreme Court or testimony from circuit court judges, just reiterate for me the genesis of this legislation, because I need to make sure. Now, is everyone always happy with everything? No, but I need to make sure that that my highest court is okay with this. And I need to, and do we have an opinion from the circuit court conference on this?
Mr. Chairman, this was brought to me at the request of the chairman of the circuit court conference, and I've been conferring with them over the past several months. And I've also informally consulted with other circuit court judges, albeit, to be unfair, I did not consult directly with the full-time circuit court magistrates who would be the subject of this potentially. So to be fair about that, it's my understanding that the circuit court judges are trying to solve a problem and they wanted to give the Supreme Court the tools to do that if necessary. Obviously, by adopting this, so it's my understanding, and I did receive an email confirmation because after this bill was drafted, I sent it back to the chairman of the circuit court conference and a couple of other circuit court judges saying, is this language what you intend? Will it solve your problem, or would you like to amend it? That was because I wasn't sure that I'd gotten it right. And the response I got was that the chairman of the circuit court conference was happy with the language as is. Again, that's of course hearsay being offered for the truth of the matter asserted.
Sure. I just remember the state of the judiciary. And I remember the Chief Justice saying there were some bills out there floating in the system with some, misconception on the court in them. And this ain't it. This ain't that bill. I think I know what the Chief Justice is talking about, but I just want to make sure we're working in conjunction with our judicial branch to the extent we can. I appreciate, of course, as you know, former vice chairman of judiciary, you're now on appropriations. So, when you have to ask the agency where, potentially the job that you're cutting, that's just a reality of government. So I can appreciate that opinion would be different from the full-time magistrates. But that just is what it is, I guess, sometimes. Further questions for Representative Stith? Thank you, Representative Stith. Members of the public, Clarissa, do we have anyone in our virtual world that would like to testify on this bill?
Mr. Chairman, we do not.
All right. In the room, you're all here for the next bill and the last bill. Okay. Seeing no public testimony, then I will close public testimony on the bill. Do I have a motion on the bill?
I would move House Bill 3, Mr. Chairman.
Moved by Representative Zwanitzer, seconded by Representative Larson. Discussion or amendments on the bill, Representative Yin.
Thank you, Mr. Chairman. I'm extremely uncomfortable approving this, voting aye on this bill without some statement from the judicial branch. Literally anybody from the judicial branch would be really nice. I did look at the Supreme Court, well, the judicial branch's website, and that they did say that there are 4 full-time magistrates in Bighorn, Johnson, Niobrara, and Platt. So, it wouldn't be a lot of magistrates that they would be looking over, but again, I feel really uncomfortable giving more work to the Supreme Court without them here to testify in any capacity.
Yeah, Representative Yin, I appreciate that, which is why I held Representative Stith's feet to the fire on that question. I think, if he obviously is not misleading us. If he did mislead us on the position of the courts, I think that that would make his law practice very difficult going forward. But maybe to give you a little bit of comfort, Representative Yin, because you are newer to judiciary, not newer to the legislature, but I don't know that it's necessarily uncommon to not hear from, just in general, judges. The judiciary has an extreme respect for the legislative process. A little bit, it's a different dynamic than the executive branch that constantly testifies on our bills. Just giving you a little bit of comfort that it doesn't necessarily mean that something nefarious has happened. It's just common. I meet monthly with the conferences, and particularly with the Supreme Court. And that's a newer thing for the chairman of judiciary, but just trying to get them more involved. And I preach to them, please come and testify on all bills that deal with you. We want to hear from you, but just letting you know, it's a little bit of a different animal. Representative Craigo.
Thank you, Mr. Chairman. I just wanted to give a little bit of background so everybody kind of understands how this whole full-time magistrate judge thing works, because we have one in Johnson County. And essentially, we have a circuit court judge that's appointed to the 4th Judicial District, which is Sheridan in Johnson County. And that particular judge is based in Sheridan. And Sheridan's much bigger than Johnson County, has a much bigger docket, has a much bigger caseload. And so she spends most of her time in Sheridan. And so we don't have enough judge power to cover Johnson County. And so our full-time magistrate covers us and handles search warrants, handles protective orders, handles all of the civil stuff that runs through circuit court in Johnson County, all the way up, cases all the way up to $50,000 in damages. Everything in between, bond hearings on criminal matters that don't happen. Our circuit court judge comes down on Mondays, and other than that, she is tied up and she is busy full-time in Sheridan. And so it's, she does other stuff remotely at times, but he handles all of our stuff. And so I understand the bill only allows the Supreme Court the opportunity to review all that stuff, but it causes me a little bit of angst and scare in our county especially, because I don't know what that'll happen. What would happen? Does it save us money? Does it actually cost us money? If we get rid of that judge, do we end up having to actually hire a full-time circuit court judge? I'm sure that's what would happen. There's no way that our current judge could handle both counties full-time. There's too much. She works too hard as it is. So I'm against the bill, and for that reason, but that's based on what I know in our county. And I'm sure that's the same situation in the other 3 counties that have to deal with a magistrate judge, that they need the magistrate judge, and that's why they have it. It's not a waste of resources, but I don't know their situations. I just know ours and how hard our judges work. So thank you.
Yeah, I appreciate that. Thank you, Representative Craigo. I do think I understand your concern for for the rest of the committee. I think we're talking about the Supreme Court dealing with its own lower courts. I don't imagine that the Supreme Court would make a reduction in detriment to its own court system, right? So they intimately know their court systems. I don't understand why they would reduce or remove a magistrate, knowing that that would, you know, cause more work on the other conference or cause the full-time position. I mean, they caused the full-time position. Now they got to circle back to the appropriations committee and beg for more money. I mean, it's like saying, I'm going to give the manager of a company the authority to decide if they should have employees or shouldn't have employees. Why would the manager make a decision to the detriment of his or her company? Right? Maybe I'm missing something, but I mean, the court system, we don't have a unified court system, but the Supreme Court has every interest in making sure that the court systems work well from the bottom level to the top level, right?
Thank you, Mr. Chairman. I would agree. And I'm not casting dispersions on any level of the court. I also have to practice there. So I guess the way I read the statute as it is now, it leaves that control in the local judge, the local judges, if there's more than one. In our case, it's only one, but you know, lots of districts have many circuit court judges within that
But
district.
then that part's not stricken from the statute,
That's right.
correct?
It's
So
in the current statute.
Okay, so both options will be available still. With this bill, the Supreme Court will have an option to remove a full-time magistrate, but the circuit court judges of the circuit by unanimous vote could still remove the magistrate if they, is that how you read it?
Yes.
Okay.
My point, Mr. Chairman, was just that sometimes those are decisions that would be better left to the local judicial officers. Oftentimes, I mean, we can look at numbers. I mean, I think this will end up being a numbers game at some point. It's going to be, how much money does it save us to cut that judge? And they may not know on the ground what that judge actually does on a day-to-day basis. Whereas your local circuit court judge or judges, typically I'm going to guess that most of these, it's one circuit court judge, and that's why there has to be a magistrate. I don't know. I haven't gone and looked at all the other counties, but that's my guess. And so it's probably just going to be one, and they're probably thinking to themselves, I have to have that help. I can't cover one, or some of the districts are more than 2 counties, but I can't cover 2 or 3 counties by myself. It's not possible. So, and that's what I'm thinking. Is it, and we look at it from a financial point of view only, possibly, and not actually what services are being provided to the people on the ground. In my case, in Johnson County.
Representative Crago, what if the bill said that the Supreme Court had to confer with the local circuit court judges in order to make that decision? Would that make you more comfortable?
No, Mr. Chairman.
Because what kind of circuit court judge would tell a Supreme Court judge no? Okay. Vice Chairman Washit.
Thank you, Mr. Chairman. Perhaps someone can answer, but I do believe there are part-time magistrates as well that's provided for in statute. And so it seems to me that this bill envisions perhaps a worst-case scenario economically in the state where a decision that's detrimental to the judiciary, there may be no alternative. That things get financially tight, positions have to go. You could replace a full-time with a part-time, or more than one part-time without benefits, those sorts of things. So I think that this bill envisions that scenario where things are such that somebody has to be cut because of financial concerns. So that's my sense of it.
So Representative Washington, so yeah, you're particularly talking about the bottom of page 3 onto page 4. 2 things that it says. One, nothing in this subsection would prohibit the determination of the elimination of the full-time position from coming back, nor prohibit the appointment of a part-time magistrate, which is really what you're getting to, right?
Yes, Mr. Chairman, exactly. And well, I trust that the Supreme Court nor the circuit court judges are going to impose something that's detrimental to the judiciary in that particular circuit. I think this bill envisions a day where they may have no alternative.
Representative Grego.
I think Representative Washit is correct. That's what the bill is intending to do. I'm just not sure I agree with it. So, you know, we still have to provide services, you know, judicial services are important and the availability of a judge, especially in my county, is paramount. I mean, if I need to get a protective order for one of my clients and I can't get the judge in there to do it and it needs to be done today, that's a big deal to me. And so, you know, that's how I'm approaching this, and that's my fear. I'm not saying it's 100% founded, that I'm not saying that Armageddon's coming because this bill passes out of committee. I'm just telling you how I feel about it and representing my constituents in my county, being one of the 4 that actually have one of these full-time magistrates. And we even have part-time magistrates in Johnson County on top of the full-time magistrate, which, to be honest, are just lawyers in town who fill in on a case when the full-time magistrate, or if the circuit court judge is unavailable, say in Sheridan County, they go on vacation. Rather than us hiring a judge for a week, we have a part-time person who is always just a lawyer who's gone through some training to be a part-time magistrate, and they come in and handle a case or handle a couple hearings or a bond hearing or whatever. That's what the part-time magistrates are.
Yeah, and so just kind of following up on that, Representative Craigo, so the language on line 15, 16, 17 says, in making a determination, the Supreme Court shall, it's mandated, to evaluate the caseload of the full-time magistrate being reviewed. So I think there's 2 things with that. One is, it seems to me, one, we're requiring the Supreme Court to absolutely evaluate the caseload. We're prioritizing that. So if there's work that has to be done, we're saying we want to make sure you're looking at that and you're understanding that we need the full-time, we need the part-time, or we don't need the magistrate. So I think the court's going to have to take that into consideration. And if the load is such, then I can't imagine they would eliminate it. What's really interesting is I would wonder if the Supreme Court evaluated it and, you know, the docket load suggested clearly the need for X number of circuit court judges. And so that's why we have the magistrate, right? Because we don't have requires X or Y, but we have X number. So we fill it. I would wonder what would happen then. I mean, I guess the circuit court could have an action against the Supreme Court if it didn't evaluate the caseload. It's very interesting. But I think the point is that I think in your concern, the priority being the caseload and making sure that you have the access, your clients or the citizens have access to justice. It's exactly what I read is the Supreme Court is evaluating, right? Representative Oakley.
Thank you, Mr. Chair, and very briefly, because it's reiterating, I think, what both the chair and the vice chair just said, but what this does, in essence, then is put the decision-making to look at all of the resources in the same hands of the Supreme Court, which makes sense. It's currently what the Supreme Court does. I mean, they look at numbers, they have it down to, you know, your caseload is 3.1 relative to the other circuit court judges at 2.9. They're constantly evaluating that. So this would put this on the same playing field and should make it so it's equal across the state. I can't see them, you know, leaving Johnson County or any other county. That's the duty that they do. In fact, so it makes sense to me to put all of the decision making to move those puzzle pieces with one body, one decision maker.
Thank you. Should we vote?
Yes.
Question? Is it burning, Representative Yin?
Mr. Chairman, it appears that we do have a circuit court judge on the webinar now. as an
Aha.
attendee.
Clarissa? Let's open up public testimony. Can we admit this circuit court judge?
Mr. Chairman, I have admitted Judge Christensen.
I knew if I said his name twice, he would appear. Apparently, if I had said his name, can you admit him, Clarissa?
Mr. Chairman, he is admitted to the meeting. He just needs to turn on his mic and video.
Thank you. Judge Christensen, if you want to light up your video, then we can see you on our screen.
Hello, can you hear me?
We can hear you. We just can't see you. We don't know if that's intentional.
Okay, sorry. I knew this would be a problem, Mr. Chairman. I had court this morning.
That gets in the way sometimes. Judge, go ahead and introduce yourself.
I think I have your YouTube. That's the problem. Okay, how's that?
We can hear you good.
Can you see me?
We can see you.
Okay, thank you. Mr. Chairman, sorry.
Go ahead, Judge.
Thank you. My name's Brian Christensen. I'm Circuit Court Judge and President of the Circuit Court Conference. I came in late. I was going to watch this as it came up. But of course, I had hearing right in the middle of your meetings this morning. I did catch a little of Representative Oakley comments, and she is correct. This bill would basically put the review on the Supreme Court to review if full-time benefit magistrates are needed in certain areas based on caseloads and now technology, as Representative Stith has probably told you about. Our technologies are of such a shape and magnitude now that we are, our part-time magistrates, our budgets are almost nil. We've excluded those from our budget because our circuit court judges are able to cover for one another statewide. Judge Castano sitting in Sundance can do arraignments for Judge Broco sitting in Sweetwater County just by video technology. Based upon our temporary rules based on COVID, which I think a lot of those will become permanent, allows for even hearings such as preliminary hearings with the defendant's consent to be held by video. And I had recently a preliminary hearing I held for Albany County. I was sitting in my courtroom, the defendant and the public defender in the public defender's office, the prosecutor in their office, and the police officers in their office, and the clerks in their office. So we were able to handle those type of hearings without everybody traveling to the same location based on COVID restrictions, as well as now convenience for the parties. I did get a comment come back to me that there were what we're talking about, there were 6 full-time benefit magistrates in the state of Wyoming. There's now 4. One retired in Weston County and was not replaced due to caseload studies. Once a person retires or vacates that office, the Supreme Court then does have the ability to review and see if that position should continue. Again, in consultation of looking at the caseloads and consultation with the circuit court judges in that district, as well as the county commissioners. The other one that has vacated was when Judge Harrington retired. They vacated the Hot Springs full-time benefit magistrate as believed to be unneeded at that point, based again on the caseload studies. But at this point, as I think was previously stated, you could not vacate that position except by the judges in the district agreeing to do so, like was done in the 4th District up there in Park Bighorn, Washakie, and Hot Springs when they relieved one full-time magistrate. There were 2 circuit court judges at that point that unanimously agreed. The issue comes down to because of a magistrate sitting in a position where he's at in a district The circuit court judges may feel uncomfortable doing that because they stand for retention in those counties, or they may have a relationship with those individuals. So it was thought that this needed to go to a more independent arbiter in the Supreme Court who controls our budgets to begin with, to review if a full-time benefit magistrate is needed. Each full-time benefit magistrate has a impact on the state budget of $50,000 to $70,000 a year. And so this came to light and ahead, as has been stated, when we were looking at budget cuts, and it was requested that the judiciary look at budget cuts. So that's what this is. Do we have positions that need to be vacated or not? And I believe the bill as written allows that every 4 years on retention years. Mr. Chairman, any questions?
Yeah, I think we got a couple for you. Representatives want it, sir?
Thanks, Your Honor. I guess I need some extra.
We're not in court.
Still treat.
I'm
with
just
respect.
kidding. You can call them whatever you want.
I guess I need a little bit of understanding. These full-time magistrates, from what, and I just need you to correct me if I'm wrong. From what I understand, they have every right, duty, privilege, benefit that a circuit court judge has. But for some reason, the legislature hasn't given you more circuit judges in that county, but then the Supreme Court and the county commissioners can decide that they need more judges, even if the legislature hasn't given any more circuit court judges. And then you give them full pay and benefit. Would I be correct that it's at a cheaper level than what we pay circuit court judges? And how is that fee or that contract? Is there a standard provided, or is it negotiated for each magistrate?
Thank you, Mr. Chairman, Representative Zwaniter. They are cheaper because they are presumed to only be operating in the county for which they are selected. So if a full-time benefit magistrate is sitting in, as previously in Weston County, but needed to cover in Crook County, they would have been paid as a part-time magistrate in Crook County. They were created when the original circuit court system was designed, I believe back in the early mid-90s. Every county did not get a circuit court judge based upon the workload. And it was felt that the circuit court judges in the district would oversee that position, but they may need those positions for the workload that was anticipated. So they were put individually in, let me think here, Niobrara, Platte, Weston, Hot Springs, Johnson, and Bighorn counties. Every other county had at least one circuit court judge. Since that time, to increase circuit court judges, there needed to be legislative action based upon recommendations from workload, such as in Natrona County and Laramie County. A circuit court judge has been added in both of those over the last 25, 30 years based upon the workloads here. What's happened is the need for the full-time benefit magistrates. There are some counties that may not require them at this point, but instead of, that's not my call, that's the circuit court judges in that district, but the circuit court judges, if we have new circuit court judges in a particular district, they feel they can cover those, but they don't feel comfortable signing that I no longer need this full-time benefit magistrate. Since one of the reasons they may have a concern about running for retention in that county, because a circuit court judge runs for retention in every county in which their district is incorporates those counties. And the other reason is, again, a long-term relationship may preclude them from wanting to make a decision on the necessity of that position. this puts it in more as an independent arbiter with the Supreme Court, again, who has the budgetary oversight and consideration for the courts, for the circuit courts anyway.
Thank you, Judge. Vice Chairman Washit.
Thank you, Mr. Chairman. Judge Christensen, thanks for joining us this morning. I just want to make sure I understood your testimony and I'm not reading something into it. Were you saying that by implementing video remote judicial practices, that has diminished the need for magistrates, and that is part of the reason why we might be able to dispense with a magistrate in one county and cover with virtual judges?
Judge.
Thank you, Mr. Chairman. Representative Washit, that's correct. Our technology is such as it is today that we're covering for one another. Our part-time magistrates, which we do have control over, has been, the budget across the state has been reduced to minimal. Every once in a while, a judge may need one, excuse me, especially in a circuit where there's a single judge for hundreds of miles. But that has been alleviated by the video technology and audio technology that we're able to access today. Most, if not a lot of our hearings are on video technology now. The preference is to have them in person when needed for coverage. We're able to do that. So the need for part-time magistrates, as in some instances, maybe for full-time magistrates, is also diminished, as you said.
Thank you, Judge. Further questions for Judge Christensen? Thank you, Judge Christensen, for taking the time to come in and join us. We really appreciate your testimony. And even though you had other things and you got late to the game, that was still great. So if that ever happens again, don't hesitate to come on in. I'll always open up public testimony to hear from the judges.
I appreciate Representative Washit sending me a text saying, hey, get on this meeting, so I could run out of court real fast and get here. So I may need to get you a buzzer as well, Mr. Chairman.
Yeah.
Buzz me.
I called out your name twice.
Yes, I heard.
I thought maybe that would somehow make it into the courtroom. And
yeah, it certainly did, as well as Representative Washit's contact. So.
All right. Well, thank you, Judge.
Thank you.
All right, committee, I'll reclose public testimony. We already had a motion on the bill, so we are voting on the bill. Call the roll, Kay.
Representative Crago,
No.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Williams, Vice Chairman Washit,
Aye.
Representative Yin,
No.
Representative Swanitzer,
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 7 ayes, 2 noes.
Representative Stith, I suspect this is a bill you'd like to floor manage. Even though this bill doesn't fit the flavor of the bills you generally bring to us, it's a little out of place, but
This is easy because
Yeah. all right. Thank you, Representative. Representative Worf, how much time do you think? It's not going to get done in 2 minutes. It's not going to get done this morning at all, but how long do you think House Bill 116 might take you? Because I do have a noon. I already have something else for noon, but if this isn't going to take very long, I might carry it over to noon. And it's just informal. Well, as far as testimony, how much testimony do you think you have? Okay, well, let me take a look. I'll take a look in between now and then. We'll touch base in the chamber and we'll try to figure that out. Thank you, Representative Worf.